Okay, good morning and welcome to today's meeting of the Development Management Review Committee. This is essentially the continuation of the meeting we had to abort on the 19th of June, and apologies to all concerned for that. We're going to carry out this meeting under the Council's hybrid procedures. Remote members can let their, if they want to draw attention to speak, they can raise their electronic hands. And I can remind remote members as well that they must keep their cameras on so that we can see they are here. Members in the chamber can just raise their physical hands. So we'll start with the usual apologies and substitutions.
Yes, Convener, an apology from Councillor Breeze.
Thank you. And declarations of interest and statements of transparency. So, Councillor Nicholl.
Thank you, Convener. Item 4, Brochy Cottage, Maniki. I didn't take part in the initial site visits, etc., so I will not take part in it. I will not leave the chambers, but I will be just spectating as a member of the public.
Thanks for that. And Councillor McLaren?
Yes, very similar to Councillor Nicholl. I didn't take part in the site visit, so I will just remain in the chamber.
That's fine, perfect. And Councillor Doran, have you got a similar declaration?
Yeah, exactly the same. I wasn't available on the date of the site visit, and so I won't participate in that part, but will stay in the meeting as a member of the public. That's okay? Just
to clarify, that's item 5, the one at Strathmartin?
Yes, yeah.
But you were present at the Brochy Cottage, Moniki?
Yes, I was present at that one. Sorry, yes, I was present at Maniki, but not at the Strathmartin one.
That's grand, thank you for that. Okay, we'll move on to minutes of the previous meeting, which are the minutes of the 21st of May and the 19th of June. They look fine to me. Do I have a seconder for that? Councillor McLaren. Okay. Okay, we'll move ahead to item 4, which is 1 Brochy Cottages, Moniki, and I think Mr McGuinness is going to take us through the planning side of that case.
Thanks, Convener. I just want to make sure, because this has been a while since we've looked at this case and it's been a while since members have been on site, whether it would be worth just doing a quick refresher of the case and a quick presentation just to refresh members' minds.
Yes, I think that would be a very good idea. Yes, right. On you go.
Bear with me, I'll just share. Sarah, I can't share my screen. If you don't mind fixing it.
Yep, just let me have a wee look, Anthony, thank you.
Yes, Councillor Nicholl.
Agenda number 5, this Strathmartin one, has that already been viewed?
Has that already been?
Microphone on. I don't think I've been on that either. You need to put your mic on. I'm sorry, I have not been on the site visit for that.
That was the site visit where we had great trouble finding the location.
Oh well, I've just brought to my attention. I wasn't at that one.
So you weren't on that site visit?
So I will have to sit out on that one as well.
You'd have to sit out on the second one as
well. My apologies, but I was reading it as new.
Okay, right. Thanks for clarifying that one. Okay, it is a bit complex with the number of meetings we've had and the lapse of time, but thanks for clarifying that.
If everybody's ready, Convener, if you could let me know and I'll just go through this.
Yes, if you can just go ahead now, Mr McGuinness, thank you.
Thanks, Convener. Right. The case in front of members again this morning seeks the review of the non-determination for planning permission in principle for the erection of a house at 1 Brioche Cottages, Miniki. The size of the application site area is unclear, as the area is not consistently noted within the application forms. It is stated, however, within the application forms that it is 957 square metres when measured from the scale bar shown on the site plan. The red application site is measuring around 870 square metres when doing the same approach. Notwithstanding this, the application form indicates that the site related is to an uncultivated, walled area of extensive garden grounds and currently weeds and grasses of the proposed location of the new house. As the application seeks planning permission in principle only, the application drawings show an indicative dwelling location and access point. The indicated access is to be taken from existing access which serves 1 Brioche Cottages. The application form indicates that private draining arrangements would be proposed using an existing septic tank system. A connection to the public water supply is sought, and SUDs would be provided to deal with surface water runoff. I can confirm that I've had no previous involvement in the application and I have no conflict of interest relevant to the case, applicant or any interested party. I was also not in attendance at the site visit held on Monday the 15th of April 2024 for the accuracy of minutes of this committee. So as usual, I'm just going to take you through sites. So the red line boundary of the application site, if members can see my cursor, is to the east of the North Pool of Miniki Reservoir and to the south of Creighton of Miniki, to the east, to the west of Creighton and Miniki. This shows it in a bit more detail of where the site locates. The boundary of Creighton and Miniki is on the opposite side of the B961. Sorry, I'll go back. And this actually shows the boundary of Miniki as in the current local development plan. This is a bit more of the location plan of the actual location of the proposed dwelling. Number 1 Brioche Cottages can be clearly seen. So the red line boundary is the one that's in front of members this morning, just to let them know, just to distinguish between the blue and the red. This gives a bit more detail of what the indicative site plan would look like. An indicative location of the proposed dwelling in relation to the existing cottage. This is showing Brioche Cottages taken from the opposite side of the B961. This is the existing dwelling house. This is the opposite side of the dwelling house showing the potential access and the tree coverage. This is showing the application site looking east towards Creighton and Miniki. And it's a bit more closer in view to show members of what the site condition is and what is on site at this point. This is it looking southeast towards the curve in the B961, going back into Miniki and going round the south pool of the reservoir. And that is just basically the end of the presentation. So I hope that gives members a bit more information, a bit more context, because it's been a while. That's me finished, convener.
Okay, thanks, Mr McGuinness. And of course, we'll remember that this was a non-determination case, so it wasn't as though it was rejected initially by the planning service. So any questions for Mr McGuinness from those that are, which is essentially Councillor Durno and Councillor Dorn and myself? Okay. So no questions, and no questions for any other officers. We've got Mr Barnes from Rhodes in the chamber. No. Okay, right. Okay, I guess we go around the table. And how we left this one, if you going back to the original decision, was we had approved this, and it was brought back for us to articulate clearly the reasons for approval and how it was viewed in relation to the council's local development plan and MPF4. So that's what we've got to give clear reasons if we're going for approval. I think that was why it was brought back. So I'm happy to start. Just maybe go round the table initially for thoughts. Councillor Durno, you're in the chamber. If you maybe want to kick off on this one.
Right, thanks, convener. Obviously, we went to see the site visit, and we looked around, and I was quite happy with everything. I am going to go with policy 14. A, development proposals will be designed to improve the quality of an area, whether in urban or rural locations and regardless of scale. Also B, development proposals will be supported where they are consistent with the 6 qualities of a successful place. Also going on to health, he's supporting the prioritisation of women's safety and improving physical and mental health with the consideration of the lady that was an applicant. Supporting attractive, native and built spaces, and supporting the effective use of resources that will allow people to live, play, work and stay in the area. I think all these policies come under policy 14, and I would like to approve this application at the moment. Thank you.
Thank you for that. Councillor Dorn.
Thank you. Yes, so I was on the site visit as well for this one, and I had also indicated that I would be minded to approve this. However, now we have gone back and asked for the further assessment and notes from council officers on this, due to the fact that we need the reasoning of how we would approve it. It seems to me that it's more difficult to approve this than initially thought, and I agree with the kind of the summary that the officers have given here, of the different policies that need to come into play. So I think that makes it challenging. My worry would be that we would, if we went ahead with an approval today, would we be able to do an approval that would be strong enough to allow it to go ahead, or would it be sent back again? And we've had this has come up a few times within DMRC now. So I think that's my question, really. I agree with the assessments that the officers have made. However, I do think this one could have been approved, but the reasons given weren't strong enough. So now we're in this position.
I think that's a good summary, Councillor Dorn. I mean, I'll maybe give you my thoughts on this one. If we look at the council's development plan, which is the 2016 document, the officers are effectively saying two things there. Firstly, it's outside the development plan area, and secondly, under TC2, it fails the test there. Now, on the first one, the development plan area, I think there are some material considerations. We allowed quite a significant development on the other side of the road, if you know what I mean, from the reservoir, which allowed round about 10 houses to be built, and that was outside the development area. This is one house, and the development area was very, I would have thought, very. It was an odd shape of development area, because it included the school, and it included a previous housing development closer to Dundee, but didn't include the vacant land between the two, and that's where these 10 houses were built a couple of years ago, 2 or 3 years ago. So we allowed that. And I see Mr McGuinness has got his hand up. Do you want to interject at this point?
I would like just to make this clear in the implications of policy DS1, which is what you're referring to, Councillor, and what Councillor Doran was referring to. The houses on the side of the road that you're referring to are contiguous to the development plan boundary. Therefore, they're more in line with policy DS1, and it does have certain states and certain categories of doing it. So that was probably one of the reasons why that was probably granted permission, because it was contiguous to the development boundary of Creighton and Maniki, even though that site was out with it. This is a wholly different application, different type. So if members are using the terms of precedent, it has to be a like for like precedent to use. This is 10 houses opposed to one. This is 10 houses that was contiguous to the development boundary, where this one house isn't. It's out with the development boundary and it's separated by the road. So it is not contiguous to the black line of the development plan. I just have to make that clear in terms of planning policy, in terms of the adopted local plan. Those are the considerations there. There are 3 criteria within that policy to allow development, and just need to make clear. So when you're looking at a precedent argument, it has to be like for like and within the area and of the same terms to allow that as a material consideration. In my view, this is not a material consideration in that view. I have to just be very clear on that. Happy to have Mr. McQueen come in and on that if he has any different views. If he's in agreement with me, then that would be my standing advice to the committee.
Thanks for that, Mr. McGuinness. I guess I actually was on that DMRC, I think, a long time ago. To that point, I would say that the development plan area for as all of them are, is now 8 years out of date, right? It's 8 years since it was. I'll just let me finish. It's 8 years old. When that plan gets reviewed and updated, it will have to be redrawn because we've built the additional houses, the 10 houses that I talked about. My argument to you would be that development plan area includes Brochy Cottages 1 and 2 and the adjacent house. And the logical place to finish that would be the boundary, which is where they join the reservoir. I don't understand why we've simply drawn it round the 2 existing houses and not taken it to the logical dividing point, which would be the reservoir. So there's a bit of, I think, illogicality, I would suggest, about the current development plan area for Maniki. That would be my point to you. And I don't know why it was drawn that way. I suspect it was just drawn around the existing houses, which doesn't strike me as a particularly logical approach. You better see if you get your hand up, so on you go.
Just to remind members, the sort of oldness of the document is irrelevant. It is 8 years, but there is no 5 years anymore. That was replaced in the new Planning Act. So the length of the development plan is irrelevant. The oldness of it is, and technically irrelevant as well. Just to make that clear, it is the development plan, regardless if it was adopted in 2016. But I do agree with members that it is 8 years, since it was last updated. In terms of the development boundary, was before my time, Councillor Duff, so I can't actually tell you how it was done. In my experience, it's always done round field boundaries. It should always be done round field boundaries because that makes more sense and it's got a more tangible line. I take into a point that members feel that the boundary is illogical, but it is the boundary. It was the boundary approved by council in 2016, and it was the boundary it went through a local development plan examination. It was drawn at that time probably to go around the existing form, but because I wasn't here and involved in the plan, I can't testify to the logic of it. I can just give you my professional view. So I would also say illegality or agreement with the boundary is a relevant material consideration as well. It is the boundary in an adopted development plan until it is replaced, until it is redrawn. Then it is the boundary that the policy applies to and that NPF 4 applies to. That would be my professional advice to you. I cannot sort of give members any clarity of what the new development plan will look like, but yes, I would agree with the convener that any development would then have to be taken in for the development boundary. So in that part of Creighton and Maniki, it is highly likely that that new development will be taken into the boundary because that's what you do with allocated and consented and built sites in any new development plan. So I would agree with the convener there that it is highly likely that the new development plan, once adopted, will include those within the settlement, but it would still do that on the boundary of the road unless members wished any parts of Creighton and Maniki on landscape terms or development terms to be taken into account in the new development plan. However, I must advise members that development plan is still in production. It's still at evidence report stage. These decisions have not been taken. It has not been looked at. Therefore, extending the boundary to this is irrelevant as well at this point. But I take the convener's point and going forward that the 10 houses would be included within the development boundary of Creighton and Maniki in any new development plan. But that we are not at that stage yet. I hope that helps, convener, a bit.
Okay, thanks, Mr McGuinness. Councillor Dorn.
Get your D's
Yes,
mixed
please
up.
put your microphone on.
Thanks, convener. I just want to make a point that TC2 says that housing will be supported for a single new house, regeneration of a redevelopment, and also on policy 17, it said C supports and sustains existing fragile communities and supports local housing outcomes and is suitable in terms of the location. I just feel on this, maybe if we put in some conditions going forward, saying that the design has to be of a high standard and minimise greenhouse gas emissions, something like that. You're
referencing policy 17 of MPF4. Yeah. I think I was just at this point going to ask Mr McQueen for his views. I mean, would you agree with me that there is an argument if the development plan is more than 5 years old, that there is less weight can be put to it? Is that not the general thrust of the decisions that are made, that if the development plan is older, then less weight can be placed on it?
I think from a procedural and legal standpoint, that is the policy. That is what you have to work to. You then have to take into account your own or what material considerations may be to allow you to depart from that. I don't think it's necessarily the age of it that would actually influence. It is the policy.
And we are also advised now that we've got the Council's Development Plan 2016, we've got MPF4, which is 2023, and we're advised that we should put more weight on the newest document, which is MPF4.
You certainly have to take into account MPF4 and the policies that are within that, yes, absolutely.
Okay, thanks for that. Well, I think I would support Councillor Durno's contention that policy 14 supports the development. I've been looking at policy 17, which talks about supporting vulnerable communities. It talks also, clause 7 talks about subdivision of an existing residential dwelling, the scale of which is in keeping with the character and the infrastructure provision in the area. So I would argue that both 14 and 17 supports this development. And if we need any other mitigation measures, my comments about the age of the development plan and frankly the illogicality of it, I think we have to take into consideration, because I'm not sure when these development plans are produced, and it's a huge document, does every local member check every detail? And I suspect they don't. I just feel this was an illogical development plan, to be quite honest. And I think for me, that is a material consideration. So I see Mr McGuinness has got his hand up again.
Yep, just for clarification, I agree with Mr McQueen, what he has said. The thing about 5 years was in former Scottish planning policy. That has been replaced by National Planning Framework 4. So and you're correct in your association that if there is a conflict between policies, then your plan prevails. That is in legislation. So in this case, if there is any conflict with policies in the adopted local plan, MPF4 prevails, and that's where the decision must be made. In your point about MPF4 policy 17, if I can get my mouse back to it, 17A7, which is, it reads, is for the subdivision of an existing residential dwelling. I must remind members, this property is not being subdivided. It is an actual new house that's been built on a separate part of the plot that the applicant doesn't say is in the curtilage. So it's a subdivision of the existing residential dwelling, not a subdivision of the plot, is what this part of MPF 417 is stating. And then development management's response to the members' instructions, it clearly states that it is not the same thing within it, and that any of the circumstances of this thing does not comply with MPF4 policy 17. So just for practicalities and legalities of any decision making, I have to make it clear to committee, this is not a subdivision of a residential dwelling house. That would apply to the subdivision of the principal house here. this is a separate house. This is a new house on a separately walled garden part of the plot. That would be subdivision of a plot. If we were doing it that way, this is subdivision of a dwelling, is what it is clear in black and white in NPF 4 policy 17A7. So we have to be very clear on any moves or any policy determination to make sure it's a competent decision going forward. If Mr McQueen disagrees with me, I'm happy for him to say so, but that is what it says, subdivision of an existing residential dwelling, not subdivision of a plot. Hope that helps.
To planning interpretation.
Okay, I mean, take your point. I mean, if that's the case, then I'm happy to go with policy 14, Councillor Durno's, the one that she talked about a few minutes ago, and we could say that MPF 4 is the newer document, and that if you effectively trumps the Council's Local Development Plan 2016. So I'm certainly I'm happy to go with that argument made by Councillor Durno. Yes, Mr McGuinness.
I don't mean to be pedantic. If we are departing for both NPF 4 and the development plan, which are the principal policies, then that has to be clearly stated. Policy 14 is in terms of design grounds. This is a planning permission and principle application which has no design on it. So we can't actually assess that part of the policy, although conditions could be applied to that going forward. So I just would make that clear.
Yeah.
We have to be very careful in this one because it's the strategy of the plan and the strategy of NPF 4. So if we're going against that, then members' views have to, be in that vein. Clear decisions would have to be, because this is a planning permission and principle, the design hasn't been set. Therefore, I would question that approach as being the right way to go. I think members would have to consider about what other material considerations or reasoning for determination of abandoning the spatial strategy in the current development plan and NPF 4 policy 17, because to me, those are the two main considerations of policies that members are sort of having issues with this morning. So therefore, it would be, if members are going down the route that they view this as a departure from both, then the reasoning has to be clear on why they're departing from the spatial strategy in the plan. In my professional view as advisor, design grounds is one of many considerations. It is not, for me, that the weight on this wouldn't trump that. You have to be more specific in why we are moving away from the spatial strategy of the plan. Design grounds is one of it, but you have to sort of look at the criteria in both of the policies and come up with a reasoning of why that house should be built. What's its reasoning? Why should it be allowed out with the spatial strategy of the development plan? I'm sorry about being pedantic. I am trying to help here and get members to that. But in my view, as a professional planning officer, design grounds are one, but it doesn't trump the rest of NPF 14. The rest of the plan and the policies have to be considered in a totality. So I get the reasoning of committee. That is one reasons that you could have, but we still have to focus on the spatial strategy of the development plan in NPF 4 in that regard would be my advice, unless Mr McQueen disagrees with me in that. Sorry about being pedantic, convener.
Okay, thanks for that, Mr McGuinness. Councillor Doran, do you have any thoughts here, because you've been sitting here, you got any further thoughts from having heard the debate so far?
Yeah, I mean, like I said, I'd agree that this one should be allowed to go ahead, but finding the appropriate reasoning to allow it is causing a big challenge. I think my final point would be maybe to ask for comment on relating to policy 17 and the assessment of the fact that this is a home which in the application is noted that this would be accessible for, I think it states within that it would be an elderly person or a carer working with them on the property. And policy 17 does note that homes in rural areas will consider development will contribute towards local living and take into account identified local housing needs, which in the policy outlines affordable housing. But is accessible housing, does that fall under policy 17, and is that something that could be looked at?
I'm just having a look at 17 at the moment.
It doesn't mention accessible living within policy 17, but it does mention local housing needs, and in areas, rural areas where we've got lots of old homes, is that something that could be considered there? It may not have been looked at yet, as obviously the policies are still pretty new, but that would be a question that I would have, because it would allow communities and people to stay within their local areas, if they could have property that would then be accessible for them. That would be my question around the application of policy 17, and whether or not it could be looked at in that context in this instance.
Mr McGuinness, I see your hand up again.
If it would be helpful, Development Management have covered that in their report, because the applicant has raised it. I'll read it out just to save members trying to find it, because it isn't done by paragraph numbers or pages, so I'll just read this out. This is the view of DM. In terms of other material considerations, the information submitted by the applicant in support of the application has been reviewed. The applicant suggests the existing property at 1 Brioche Cottages lacks accessibility, and the proposal, designed to modern building standards, could provide accommodation for the care of an elderly relative. Although development plan policies seek to promote accessible development, the lack of accessibility of an existing property would not be sufficient to justify the erection of a new house on a site which does not comply with development plan policy. So I'll just read that out because it was in Development Management's response to committee's instructions to them. So they have covered that for you, Councillor Doran. So I hope that helps in some way about what the planning authority's view is on that matter.
Okay, thank you. I just wondered whether it had been assessed under that policy, like 17 frame, but perhaps it already has.
I mean, I'm looking at 17 and 17C, development proposals for new homes in remote rural areas. Now, I don't know that we would consider this to be a remote rural area. That would be questionable, I would think. But I'll read you anyway. It says, will be supported where the proposal supports and sustains existing fragile communities. It supports identified local housing outcomes and is suitable in terms of location, access and environmental impact. I think there's for me, there's a need by the owner. They want to develop this. It's a small rural community, and I cannot see the detriment in many ways to allowing it to go ahead. There's some technical points which have been pointed out by Mr McGuinness. I think my reading of policy 17 generally is, we're into, what is this, whether this additional ground is garden ground or not, I'm not terribly clear what it is. Is it brownfield land? I don't know. I mean, I'm not terribly clear what it is. I certainly, in general, I'm in favour of the development. I think we're trying to find a way of legitimising that decision. If you go back to the previous councils, before we had MPF4, I would have seen this at the time as a rounding off of a number of houses, and I still see that, because if you look at there are the two cottages and there's another house to the right of those, I would see that as a rounding off of those. And as I said before, I think that the reservoir is the logical point where the development area would cease, and why we've cut it just short of that natural barrier seems an illogical decision. I think that is a material consideration.
If that's your view, yes.
I think it is. I think that I guess I would say as a material consideration that the original development area does seem to be illogical, and I think that's something you could argue about, but I think that's quite a strong argument. Arguably the fact that we've deviated from the development plan area before, Mr McGuinness has got his interpretation of why we did that. I think we again said it was illogical. We said we've got the school, which was in the development area. We had a patch of undeveloped land where the developer wanted to build some houses, and then we had maybe a 1980s development on the other side, and we said, well, why is the bit in the middle not part of the development plan? It's on the same side of the road that runs through there. Why was that not in the development? And that was approved. And I think it was the same illogicality argument that was used. I think there was a car park in the school which were in the development plan area. There was then a patch of undeveloped ground, and then there was some more, I'd say that earlier, maybe a 1980s, 1990s housing estate, about 15 houses was in it. It seems illogical, and I think that would be my material consideration to support the approval. Sorry, Councillor Dodd.
Yeah, I just want to add, this is obviously the proposal for a site for the house. We have to approve the site of a house there, but this still has to come to development standards regarding what the design and implications of the house. And it's not to say the applicant might not build this house, even though the planning permission may be gained today. With the economic climate, we don't know if the plans might not go through. So I think initially we're just the outlining permission today is what we're doing, and I think that should go through as the things I've stated earlier.
Yeah, you're pointing out this is an outline planning permission, and the detail would have to come forward as a separate application. What we are really discussing this morning is the principle of whether a house can be built here or not, and you're quite right, a separate application would have to come forward from the applicant when they actually decide exactly what they want to build. Are you, Councillor Doran, I'm conscious you were kind of sitting on the fence when you gave us your original thoughts. Have you kind of firmed your views up based on what we're talking about?
Yeah, I think there was a weakness in the argument relating to policy 14, approval based on that. I agree. I think the drawing out of the local development plan didn't make sense to me. That part of the site where the existing houses are wasn't included within that. So an argument around the fact that the local development plan drawing out of that it doesn't make sense and should be this should be allowed because of that. I would agree with that on this case.
Okay, I think we've probably spent enough time probably discussing this now. I think probably if I could summarise and say that we agree to approve this application, which is not an appeal, remember, we're approving this application 23-00400/PPPL. We're approving it because we believe that it is consistent with MPF policy 14, and we believe that the original development plan area for Maniki was designed in an illogical way, and that the logical end of the development plan area is the reservoir, and that would, if we were drawing it and thinking about all these issues, and we also wouldn't have included the bit I mentioned before on the other side of the road where we had a gap. That again seemed to be completely illogical, and we've already allowed development there. So I think the development plan area is I can't see any reason why you've stopped it short of a natural boundary. It's land that cannot be used for anything else apart from, as this applicant would like to do, build another house. I'm conscious Mr McGuinness has got his hand up again.
It's just the usual one when we get to this this part of proceedings, convener, before you actually formally agree it, is the conditions need to be looked at again, just to make sure you're happy. I have gave a copy to Ms Forsyth to circulate to make it easier for me to not put it on the screen, but for the purposes of a public meeting, I will flash the conditions back on the screen, and hopefully Ms Forsyth can actually just circulate the proposed conditions to the members considering this decision, so you can read it.
Thanks very much for that, Mr McGuinness. Yes, thanks for reminding us about that point. The suggestion is that we recess for 5 minutes to consider the conditions and perhaps discuss those in private before we come back. I think we'll have to ask our visitor to leave for that 5 minutes. There'll be a seat outside. We'll give you a call when we're ready.
Claire, can we stop the live stream, please?
Okay, thanks for the slight delay for the recess. We'll just restart the meeting. We'd agreed to approve the planning application, and I think Mr McGuinness is just going to take us through the conditions that will be applied to that application. And they're now on the screen. Over to you, Mr McGuinness.
Thanks, convener. I don't particularly think I just need to read through them, but generally what the conditions are doing is basically stating the terms for the approval of matters reserved for planning permission and principal application coming forward. So that basically says the development must be approved no later than the expiration of the 5 years beginning when the date which permission is granted. So that's the date the decision notice is issued. It sort of then gives sort of the decisions that you've got a 3-year period to get in the second stage. And then it sets out those for the applicant as well. And it gives the time periods which this has to be done. So these are very standard committee decisions that we put on planning permission and principles. And the next one is basically sort of saying plans in particular. So this is setting out what needs to be provided with the next application to be considered. So this is design grounds, external appearance of the building, the layout of the site, including access, car parking and turning spaces, and what that must be in accordance with. And it's actually making it clear that the drawing that was submitted with this application is not approved. So the indicative layout in this decision is not approved. That has to come forward with the new thing. So that's just setting out the matters for approval for the next application, so that the applicant is clear in the decision notice of what they need to do for the next stage of the planning process.
Okay, thanks very much. Thanks very much for that. Are we all agreed with those conditions? Happy with them?
Agreed. Thank you.
Okay, that's grand. I'm seeing nodding of heads from Councillor Dorn. Okay, I think we can put that one to bed, so to speak. So that, just to clarify, that planning application 230040/PPPL is approved, subject to conditions that Mr McGuinness has just shown us. And are you happy you've got enough recorded, Sarah? Okay, that's great. Thanks very much. Okay, we'll now go on to item 5. And again, I will make the apology for my pronunciation, but Tich Firme Hill Houses of Strathmartin. And I think we can invite Councillor McLaren into the meeting now, because he was on that site visit. And Councillor Dorn wasn't, so she will have to sit out of this one. And Councillor Nicholl, you were at it. No, you weren't. So it's Councillor McLaren, Councillor Durno and myself. So I think these are the three who can consider this one. It's complicated. Okay, so we'll ask it's Ms Milne that is dealing with this one, is that correct?
Yes, that's correct. Yeah.
Okay, well, I think if you can just over to you and take us through the planning report on this one.
Thank you, convener. I will put this on the screen. Right, hopefully you can see that on screen now.
That's fine.
Right, thank you. Right, okay, so this is a site, and I am just going to go with your pronunciation because I was also unsure of how to pronounce this. But it's for the refusal of planning permission for the erection of a dwelling house in principle at Tich Firme Hill Houses, Strathmartin. So the case in front of members of the Dmrc seeks the review for the refusal of an application for planning permission for the erection of a dwelling house in principle. The application site is to the north of an existing residential property and measures around 570 square metres. An existing access track lies to the east of the site, farmlands to the west, and residential dwellings to the north and south. An indicative drawing has been provided which shows an 125 square metre L-shaped property in the centre of the site with a 290 square metre area of grass and amenity space, 155 square metres of hard standing and parking for 2 vehicles to the north of the property. The drawing also shows an indicative septic tank and surface water soakaway within the site to the west of the property. The submitted application form indicates the dwelling would be connected to the public water supply network. Foul drainage would be directed to the septic tank, which would discharge to land via the soakaway, and surface water drainage would be dealt with by sustainable urban drainage systems. I can confirm that I've had no previous involvement in the application, and I have no conflict of interest relative to the case, applicant, or any interested party. I was in attendance at the site visit held on Monday, the 17th of June for the accuracy of minutes of the committee. So, so this is the location plan. The site is right at the very, very top. You can just see outlined in red there. North of Strathmartin Hospital site. This is the indicative site plan. So the area in blue is the area that is owned by the applicant. So it includes all of this except the house to the south, Brenlin. And you can see the site itself outlined in red. And as I said, it shows, say, indicatively a sort of L-shaped house in the centre of the site. You can see just to the north of it, there's an area, the access into the site, and an area of parking for 2 vehicles, and then just the landscaping garden area around the house. So these are quite a lot of photographs from the site. Also, you'll remember this from the site visit. So this is from the access track looking west. Yes. So this is the site had been used for a chicken run. So this is the existing site, and you can see there's a small shed on the site, which is bounded by this fence. This is looking south from the site. Members will remember from the site visit that the site actually extends out, takes in this area of grass to the right-hand side of the photograph, and actually goes right out to the fence with the sort of agricultural field. Again, looking across the site. And again, this is just the other shed. You can see in the very right-hand side of the picture, the small shed that was in the other photograph, and this is the other larger shed further down the site. Again, just looking at another angle. So you can see the house in the background there, that's the Brenlin, the house to the south, and then the other group of houses that are on the other side of the access track. Again, just showing the southern edge of the boundary. So this is the house to the south, Brenlin, and then just the boundary between the site under consideration and that property. And again, just looking in the opposite direction, you can see the house to the north in the right-hand side of the photograph. This is the access road. Looking back south towards Strathmartin. Again, looking in the opposite direction. Again, just the road, the access into the site. And that is the end of the presentation. It's me. Sorry, I'll stop sharing.
Okay, thank you. Any questions for Ms. Milne? Councillor Durno.
Thank you for that, Fiona. Just to ask about the actual track that's outside the house, would the road be in the development plan? Would the road need to be done by the applicant? Because it's obviously at the moment it's there's only 2 houses there, but it's quite a rough sort of road. Would that road need to be done by the applicant if this permission went through?
We've got Mr. Barnes in the chamber, so I don't know. Maybe could I hand over to him, perhaps Ms. Milne, to get Mr. Barnes's view on the road? Okay.
Thanks, convener. So it's an unadopted farm track. Whether or not, depending on whether members were minded to uphold the appeal or not, that would be a matter for members to decide whether or not such conditions should be applied.
So what you're suggesting, that if we were minded to approve it, we could put in conditions that the road was upgraded. Would you have any sort of draft conditions you could put forward, or?
It wouldn't be a requirement from the Roads Authority, given that it's not an adopted road. But yes, we could suggest a specification if members were so minded.
Okay, so it's not as it's not an adopted road, effectively you're saying from the Roads Authority point of view, we're washing our hands of it effectively, but you could give us some recommendations if we were at that point.
Yes.
Okay. Now that's helpful.
Just mindful of, obviously, if building works, there's tractors there at the moment, but there'll be a lot more, big vehicles, etc.
Can I maybe ask a question? There is this, and we saw it on the site visit, there is this path which was described as a right-of-way, but there does seem to be some question if it actually is a right-of-way or not. I see there's some documentation from the applicant suggesting it wasn't. Is there a view from the planning service about that status of that so-called right-of-way?
Yes, so the outside access officer was consulted and gave a view, and yes, their view was that the Scotways record search that was done, that the applicant had submitted, their view was that the Scotways isn't a definitive record, and it doesn't necessarily include either all the historic rights of way, and it doesn't necessarily include all land over which access rights can be, under the Countryside Act, under the new access legislation. Doesn't necessarily include all of that either, so that that's not necessarily definitive. And they also had said that, on historic mapping shows a track, and that the site, the land is land over which access rights would be applicable, and that along with the representations to the application, a few people had put in representation saying that there's an access track there and that it is used, so that they felt the access officer's advice was that they felt that it could be a right of way, and that certainly it was land over which access rights could be exercised, and that therefore it should be considered to be a path, an access path, and that it should be retained or it should be replaced.
Okay, thanks for that. That would certainly be my own view. Whatever its legal status, it clearly is a path that is used and presumably has been used for quite a long time, and it passes the house below the application site, and then it passes the house above it, and their curtilage is such that it doesn't impinge on this footpath. And I think the issue here is that the planning drawing showed the site boundary encompassing the footpath as well, and clearly if that happened, that would block the path. And I don't think that's acceptable. I would think. I think what we've had from the access office. I think I would certainly accept that. Are there any other questions? I mean, we've raised the issue with the road. That might be, if we were minded to uphold the appeal, that we might go back to Mr. Barnes and ask him for his advice on that one. But any other questions on the planning issue? Okay, don't see anyone saying anything. So basically just going round to ask members for their views on this one. Maybe you've been sitting quiet for a long time, Mr. McLaren, so over to you first.
Yes, thank you, Convener. Yes, I was at the site visit, and I think it was very beneficial. But in RSU1 areas, the Countryside Housing Supplementary Guidance requires plot sizes to be of a minimum of 800 square metres, and the plot size is 570. Therefore, the site would not constitute a qualifying GAP site. And I'm going to agree with it on this one and refuse this application. The application is contrary to policy TC2 of the Angus Local Development Plan and the Countryside Housing Supplementary Guidance, and Policy 17 of the MPF4. It's also contrary to Policy 9, Greenfield Land, Policy PV 20, and Policies 5, National Planning Framework 4, loss of prime agricultural land, Policy PV3 of the Local Development Plan, recreational access, operating, and no alternative provision made, contrary to Policies DS1 and to other policies, namely TC2, PV20 and PV3. So I would refuse this application. Thank you.
Sorry, thank you, Mr. Councillor McLaren. Councillor Durno, what's your thoughts on it?
Yeah, I'm in agreement with Councillor McLaren. As I spoke about the roads, I think it's an unacceptable condition of the roads for the site, and obviously new houses, you've got new deliveries, you've got, you know, all sorts going on when you've got new houses, and I don't think that the plot's big enough either, and I go with the contrary to Policy PV20, Policy 5 and PV3, which it's contrary to all of them, so I would go with officers on this one. Thank you.
Okay, thanks very much. So effectively we've got two members who are rejecting the appeal. I personally don't agree with you, but we are in a democracy, so I'm quite happy on this occasion just to go along with your views, and for the reasons you've stated, and effectively we're rejecting the appeal because we're accepting the officer's report on this one. So just to clarify, planning application 23/0506/PPPL, the appeal is rejected. Sorry. Well, the usual procedure is to have a vote.
Well, yes, but what I'm asking, would you be seeking approval? Is that what you're saying? So it would be a 2-1 then? You said you would go along with.
Well, you can't have if you don't have a seconder, you can't have a vote.
So, but you're not. You're still minded. You would have been minded.
I'm minded to agree with my two colleagues.
Okay, so it's unanimous.
So it's a unanimous decision. Yeah. Okay.
Yeah.
Yeah.
Sorry, I just need to clarify.
I don't like declaring whatever people do if they don't have a vote.
No, that's fine.
I think I'm quite happy to go with a majority decision in this one. Okay. Okay. So that's item 5. We now move on to item 6. Which is Muirdrum Village Boundary, Muirdrum Carnoustie, and that's you again, Ms Milne, is it?
It is, yes.
Okay, if you just want to take us through that one. That's the first fresh one, and I think I can relieve to say that everyone is now in the meeting. So we've now got 5 members round the table for the first time. So on you go.
Sorry, I hadn't unmuted myself, but I'd put the presentation on. Right, here we go. So the next item is a site at Muirdrum Village Boundary. So yes, the case in front of members seeks the review for the refusal of an application for planning permission for the erection of a fence and gates and the siting of storage containers at a site at the village boundary, Muirdrum Village. The site is approximately 750 square metres in area. The application proposes the installation of 5 6.1 metre, 0.5 metres wide and high storage containers on the eastern boundary of the site, and the erection of a 1.9 metre high fence, including an access gate wide enough for 2 vehicles to pass one another for 95 metres along the site boundary with the road to the south, between the neighbouring property to the west and the bridge over Panlathy Mill Burn to the east. As the works proposed have already been undertaken, the application is in retrospect. Members should be aware that this application is the result of an enforcement notice issued in 2020 requiring the removal of storage containers, motor vehicles, plant, machinery and machinery parts from land that includes this site, and the installation of fencing and gates, the removal of fencing and gates in excess of 1 metre in height adjacent to the main road. This enforcement notice was appealed to the Scottish Government, who upheld the decision but varied the notice to require the removal of the storage containers, the unauthorised fence and gates over 1 metre in height. So in essence, requiring them to be either removed or brought back down to 1 metre in height. And the removal of all motor vehicles, plant machinery and machinery parts that are not directly required for agricultural management. This planning history is a material consideration in the determination of the application. I can confirm I've had no previous involvement in the application and I have no conflict of interest relative to the case, applicant or any interested party. So this is the location plan. You can see the blue line, which actually looks a bit more green in this, is the land owned by the applicant. And then the red line at the bottom is the sort of site under consideration, and you can see the extent of the fence all the way along to the burn on the east end. And again, this is just a bit more in detail. So the site is down in the bottom left corner. The fence extends all the way along to the burn, and actually I think there's this existing site plan. Yeah, here we go. The proposed site plan shows you the location of the 5 shipping containers on the site. So this is just the containers, they're shipping containers, and this is the fence, say 1.9 metres high. You can see it better in the photographs. So this is obviously the access gate into the site, and the fence along the boundary. You can see here they've put sort of green mesh over the fence. And then the left-hand photo is like from the burn looking west, and you can see the fence all the way down to the parapet that goes over the burn. And then the same looking in the opposite direction. Again, you can see there's this green mesh over the fence, sort of around the access gate, and then continues down, and you can just see the containers in behind the fence there. And these are the containers, say shipping containers. This is from the neighbouring boundary, so you can see there's this sort of landai hedge for the property immediately to the west of it, and then you can see the start of the fence that continues on down the road. And then the bottom right again is just the boundary between the neighbouring property and the site under consideration. And that is the end of the presentation. I will stop sharing.
Okay, thanks very much. Any questions for Ms Milne from the members on the panel? Not seeing any. No other questions for any other officers on this one? No. Okay, shaking of heads. Okay, we'll just we'll go around the table and get people's initial views on this one, and we'll start with Councillor Nicholl. Yeah, just probably I should have said that actually. Have we got enough information to make a decision on this one? You feel you've got enough information. You don't need to see any more. Okay, if that's fine, then we've got enough information to go ahead. So we'll just go around the table, get initial views, and ask Councillor Nicholl first.
Thank you very much, Convener. The size of this property, it will be classed as a farm or small farm holding. The pictures I've seen, and I've seen past the place as well, there's agricultural machinery, there's tractors, there's bogies, there's fence posts, there's containers full of straw. There is some spare tyres for tractors. I do not see anything that wouldn't be used agricultural. The erection of the fence, I think, is a good policy in health and safety, keeping young kids, etc., out of harm's way if they want to go and play with the farm machinery, etc. So I do not see any problem with the site, for want of better words. They have used shipping containers instead of maybe buildings, but that would possibly be their way of being more economical than building. And I have no problem with what they've done. Thank you.
Okay, thank you, Councillor Nicholl. Councillor McLaren?
Yes, thank you, Convener. I think totally different on this one. I think it's, I agree with authors, it's contrary to DS1 of the Local Development Plan, and it's contrary to policies DS3 and PV6 and policy 1429 of the National Planning Framework 4. It's not in keeping with the character of the area, and it's not been designed to integrate with the landscape. So I therefore would refuse this.
Okay, thank you. Councillor Dorn, do you want to give us your views on this one?
Yeah, thank you. I agree with the officer's reasons for refusing this. I think that stands, and I agree with those points around the fencing that's been installed. It's not in keeping, and that's contrary to some of the policies as noted within the decisions that officers made. So yeah, I would reject this appeal.
Okay, thank you. Thanks for that. Councillor Durno?
I think the country councillors are in agreement here. I agree with Councillor Nicholl. Muirdrum was always a village. It was always a rural village, and I used to work in that area. And when the new houses were built in that area, they were totally out of character of the village, and there were new developments. And I feel the person who has put these plans in has done all this homework, and there's a lot of things he said on his explanation for the size of the fence and etc. Everything that he has done is under policy 29 of the rural development. And if you are in a local village, a lot of the projects that he does are probably a good asset to the villagers. He probably helps them out quite a lot with different things. And I think this is just something that happens in rural areas, and it's not known in small towns to have these big fences and the actual size of the buildings that he has, etc. I live right next door to Condor, and the fences outside Condor are right across the road from a big housing estate, and they have no effect on us at all. We don't even know they're there, and they, as you say, keep children out and they're for safe, and I don't have any problems with this. And I think that it should be left to what it is. When you look back on the pictures from hundreds of years ago, this would have been accepted hundreds of years ago, and I think it should be put through. I would go with Councillor Nicholl. I think that I don't have a problem with this development, with all the problems that they're saying. I don't have a problem with that. I think that's quite acceptable in a rural village. Thank you.
Okay, thanks, Councillor Durno. So my view in this one, very shortly, is yes, I would agree with the officers. I think this it was rejected. It's been to the reporters. They've the enforcement office. They've basically said it's not acceptable. So I am accepting what the officers are saying here, and I would certainly go for rejection. I guess we have got a split, so I will move that we reject this appeal for the reasons in the officer's report. Have I got a seconder? Councillor McLaren. Okay, and I don't know if there's a counter proposal. Counter proposal from Councillor Nicholl.
Counter proposal.
Yeah, have you got a seconder? Right, Councillor Durno. go to the vote. Mrs Forsyth.
Could I just ask Councillor Nicholl to clarify the reasons for upholding the appeal prior to the vote, please?
Upholding the appeal as it's technically an agricultural holding. The materials and everything is to do with agricultural. The fencing is to protect people from getting hurt, climbing in to play with agricultural machinery, etc. There maybe not be any specific policies for it, but it's everyday farming that would be classed as. Thank you.
Thank you, Councillor Nicholl. Just in terms of the vote then, the motion by yourself, convener, seconded by Councillor McLaren, is to dismiss the appeal for the reasons as detailed in the report of handling. The amendment by Councillor Nicholl, seconded by Councillor Durno, is to uphold the appeal and grant planning permission for the reasons as outlined by Councillor Nicholl. Please vote motion or amendment. Convener.
Motion.
Councillor Nicholl.
Amendment.
Councillor Doran.
Motion.
Councillor Durno. Amendment. And Councillor McLaren.
Motion.
The motion is upheld by 3 votes to 2. The application is dismissed.
Okay, thank you. Yes, so that, just to clarify, application 22/00346/full is rejected. Okay, we'll move on to the final item, and that is the one at Faladay Cottage, Forfar, and item 7, and back to Ms Milne for the planning views on that one.
Thank you, convener. Hopefully you can all see that. So the case in front of the members of the DMRC, this one seeks the review of the refusal of an application for planning permission. Oh, to help if I wasn't still reading for the previous one. Permission for the erection of 2 dwellings within the garden grounds of an existing house. Faladay Cottage is a detached cottage in the countryside that sits in a plot of approximately 6,300 square metres. The review seeks to erect 2 dwellings within the garden ground, leaving the existing plot to be approximately 2,800 square metres. Plot 1 is to be just under 2,000 square metres, and sit to the north of the existing house, between the house and the C53 road to the north of it, obviously. The proposed house is to be 1.5 storeys, ground floor and attic rooms, and to be finished in off-white silicon render, anthracite grey cedral composite cladding, UPVC windows, doors, roof lights and timber fascia, an oak entrance door, slate roof, glass balustrade and natural stone cladding to the chimney. 4 roof lights are shown on the east, which is the front elevation, with 2 dormer windows on the west, which is the rear elevation. The house is to sit roughly in the middle of the plot. Sorry, my battery's about to run out on my laptop. There you go. The house is of the plot, which is also to include a composite decking terrace, areas of lawn, high quality porous paving sets, an outdoor drying area and a gravel driveway. A new biodisc sewage treatment plant with soakaway is also to be located in the southwest corner within an area of lawn. Plot 2 is to be just over 1,500 square metres and to sit to the south of the existing house, between the house and agricultural land. The proposed house is also to be 1.5 storeys and is to be L-shaped and finished in the same materials as plot 1. 3 roof lights and a dormer window are shown on the north elevation, and 1 roof light and 2 dormers, one with one window and... Sorry, I'm confusing myself what I've written here. So a window and patio doors onto a balcony on the south elevation. The plot is also to include a composite decking terrace, areas of landscaping, an outdoor drying area and gravel driveway with high quality porous paving sets. Again, a biodisc sewage treatment plant with soakaway in the southeast corner of the plot is to be included. 2 outbuildings and 4 trees are to be removed to facilitate the erection of the house. A bin store for all 3 properties is shown in the northeast corner of Site 1, outside the site boundary, but where the access meets the main road. I can confirm that I have had no previous involvement in the application and I have no conflict of interest relative to the case, applicant or any interested party. So this is the location plan. You can see Letham and then the site to the east, outlined in red, the 2 north and south sites. This is the existing site plan. So you can see as existing, the main road goes there, access comes off, and there's an existing cottage, which at the moment has sort of a large garden to the north and south. So this is the proposal. The access into the house is to be extended down towards the south into Site 2. You see L-shaped house in the centre of the site, the biodisc sewage treatment on the southeast of the site. And then to the north, Site 1, the house again in the middle of the plot, with a gravel driveway with parking for indicated 2 cars, but it looks like you could probably get quite a few more in. Areas of lawn, and again the biodisc sewage treatment in the southwest corner of this site. And then right in the top corner, so it's actually with the red line of this, there's a wee bin store that is to serve all 3 houses. So this is plot 1, this is the one to the north, the north and south elevations. And then the east and west elevations. So the east is the front elevation with the front door, and then at the rear. And you can see the area of parking, the dormer windows. So this is the floor plans, and access off the access track, gravel area of parking, the house, and then to the rear of the house, this area of composite decking, and the paving sets. And then on the first floor, you can see the sort of roof lights on the front elevation, the east elevation, the 2 dormer windows, and the west elevation to the rear. And then this is plot 2. Similarly, north and south elevations. There's a dormer window shown in the north elevation without a window in it, which gives access to a stairwell. It's to have headroom for a stairwell. I'm not entirely sure why there's no window in it. And then the north elevation again, 2 dormers, but one of the dormers has patio doors in it rather than just a window, which gives access out onto this balcony above the main entrance. And then east and west elevations. Again, you can just see in the east elevation the balcony with the glass balustrade, and then the dormer window to the side. Again, ground floor plan, access, gravel driveway, area of paving sets to the front into the entrance, and then again a composite decking wrapping round the rear and side of the property to this west and south, yes. And then in the first floor is just over the north section of the L. You can see there's a lounging bedroom and the balcony area to the front. So these are the site sections, just showing the new houses in context. So this is the west section. So the left-hand side is plot 1. The new house there, and then the existing house in the middle, and then plot 2 with the new house, and then looking at it from the opposite direction, again just the same thing with the 2 houses and the existing house. So these are some photographs of the site. So this is sort of from the main road looking southwest across the site. So the bit on the right hand side here, you can see the sort of grassed area, the lawned area is Site 1. and then you can just see the existing house sort of in the background there, and then behind it is site 2. This is the access off the main road. This is site 1. So actually the wee drawings in the top right corner just give an indication of where the photograph was taken and the direction that we're looking in to help you orientate yourself. So this is basically from the boundary between the existing house and plot 1, looking north towards the road. You can see there's some ornamental trees and things on the site. And then looking from the west boundary, looking east, so just beyond this, the access track is just beyond the area of cut grass there. And then the opposite way, looking again from the road, looking south, again, this is plot 1, and you can just see the access track on the left-hand side. And then this is just another view, very similar view from the road. Actually, possibly it's in twice. Plot 1. This is plot 2. So this is the area to the rear. So this is taken from the west looking east. And this is the application states that there's 4 trees to be removed, but the actual application drawings, you can see the drawing up in the top corner here, shows like these 4 trees to be removed. But actually you can maybe see it. You can see here the existing house on the left-hand side of this drawing. But yes, this is, so looking the other way, there's like a whole load of trees on the left-hand side down here. Like this, what's shown as trees being in a sort of L shape, they're actually more in a sort of U shape. So there are actually more trees on the site than are shown on this drawing. So I think potentially there are more trees would need to be removed than are indicated in the drawing. Just something to be aware of. This is again looking in the opposite direction from the first one, looking east. Site 2. This is there's 2 outhouses to be removed. I think one of them has already been removed. I could only find one. I could be wrong, but this is certainly one of a shed, an outhouse that's to be removed as part of the development. And this is the existing house. So this here, this is the access road. So this is standing access road looking south. So this is the access road that's to be extended down into site 2 to give access into the second site to the south. And that's the end of the presentation. I will stop sharing my screen.
Okay, thanks very much indeed. Any questions for Ms Milne on the planning side? Councillor Nicholl.
Thank you very much, Convener. Maybe a funny question, but there's 3 houses. There'll be 3 septic tanks. There'll be at least 2 biodiscs. Where does all the surplus water from the biodiscs go to? Would the site have the capabilities of soak away, or will they be diverting into the water course at the bottom of the site?
So I'm just checking. There was a consultation with Scottish Water, who offered no objection but advised that as there's no public wastewater infrastructure, yes, they would have to deal with foul drainage by a private treatment arrangement. So the design statement, I say there's the two new houses are to be served by these 2 new biodisc treatment systems. Treated water will then be discharged to a soakaway. In addition, soakaways will be installed to treat discharged surface water on the site. So that is the information as we have it at the moment. Great.
Okay, thank you. I've got Councillor McLaren next, I think, and Councillor Dornan with questions. Over to Councillor McLaren first.
Just to clarify, is this garden ground at each side of the existing house?
Yes, this is the garden ground for the existing house.
Thank you.
And Councillor Dornan.
Thank you. So my question relates to the fact that the appeal note affordable home, they would be affordable homes within the appeal statement, and that isn't noted in the notice of handling of this. And I just wanted to check, is that new information that was submitted within the appeal that wasn't submitted within the original application? if that's why. And I think this is going to come down again to the definition of what a brownfield site is. So if we could get a definition of that, that would be useful as well. Thank you.
I am not. The affordable housing was mentioned in the planning application. I certainly don't see anything about it in the design statement. I would say, though, that from a planning point of view, affordable housing would be housing that's included within like the council's strategic housing investment plan that has funding. So this wouldn't be, because this isn't being funded, this wouldn't be counted as affordable housing. Okay. Within our definition of it. Also, brownfield site is land that's been previously developed. Yeah. So I wouldn't normally, under normal circumstances, this land wouldn't be considered to be brownfield land. Like garden ground wouldn't normally be considered to be brownfield land. It's land that's previously been developed, but also sites that have naturalised. So there can be sites that have been previously developed, but in the intervening period, buildings have come down and the use has ceased, and the site has like sort of naturalised back to being a greenfield site. So it's not to say that because 100 years ago there was a building there and now it's an area of grass, it's still a brownfield site. It doesn't. So yeah, that would be something for the committee to think about. Yeah.
Thank you. That's what I'd understood as well from previous discussions that we'd had around brownfield sites as well. So thank you.
Okay, any further? Okay, have we got enough information to determine this application? That's the question I'm asking. Councillor McLaren.
Thank you. I think we should have a site visit.
You'd like a site visit?
Yes.
Yeah. I'm seeing nodding from Councillor Nicholl as well, and certainly that's my own view, that I think this is one where a site visit would certainly be helpful. So if we're agreed on that, we can ask Mrs Forsyth to arrange an unaccompanied site visit at a suitable time. And that really is all for today. So thanks very much for your attendance and your contribution, and I wish you a good rest of the day. Thank you.
Claire, can we stop the live stream, please?